Welcome to The Docket. I'm your host, Corey Snow. This is episode 21. In October 2023, Judge Chutkan of the U.S. District Court for the District of Columbia entered a gag order on defendant Donald Trump and his attorneys in the ongoing criminal case against Trump for attempting to overturn the 2020 election. Trump, via his legal team, appealed that order, and Judge Chutkan entered an administrative stay of the order, meaning the order was still on the record but was not in effect, while the parties submitted briefings and pending the appeal. On October 29, 2023, Judge Chutkan issued an order denying the motion to lift the gag order and also removed the administrative stay, meaning the gag order went back into effect immediately. What follows is a narration of that order. Please note that legal and statute citations are generally simplified or, when possible, omitted for the sake of listenability. Footnotes that are directly relevant to the text may be included, although most footnotes will be omitted. The original document, including all citations and footnotes, is available at a link provided in the show notes. If you are so inclined, please consider supporting my Patreon at patreon.com/docketpod, which allows me more ability to pay Pacer and other court fees to obtain documents for me to narrate that you can listen to. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. United States District Court for the District of Columbia. United States of America v. Donald J. Trump, Defendant. Opinion and Order. On September 15, 2023, the government filed a motion to ensure that extrajudicial statements do not prejudice these proceedings. Following a motion hearing on October 16, 2023, the court prohibited the parties and counsel in this matter from making certain public statements. Defendant has appealed that order and now moves for the court to stay the order during the pendency of that appeal. The court entered a temporary administrative stay of its order while the parties briefed the motion, but will now deny defendant's motion and lift the stay. Footnote 1. The government also asks the court to incorporate the order into defendant's conditions of release. The court hereby denies that request without prejudice. Even assuming that the request is procedurally proper, the court concludes that granting it is not necessary to effectively enforce the order at this time. End footnote 1. 1. Discussion. 4 factors guide the decision whether to stay an order pending appeal. 1. Whether the applicant has made a strong showing that he is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent a stay. 3. Whether issuance of the stay will substantially injure the other parties interested in the proceeding, and 4. Where the public interest lies. Nikin v. Holder, 2009. The third and fourth factors, quote, merge when the government is the opposing party. Here, all the factors weigh against granting a stay. A. Likelihood of success on the merits. Defendant has not made a strong showing that he is likely to succeed on the merits. As the court has explained, the First Amendment rights of participants in criminal proceedings must yield, when necessary, to the orderly administration of justice, a principle reflected in Supreme Court precedent, the federal rules of criminal procedure, and the local criminal rules. And contrary to defendant's argument, the right to a fair trial is not his alone, but belongs also to the government and the public. See e.g. Gentile v. State Bar of Nevada, 1991, emphasizing, quote, the state's interest in fair trials, end quote. United States v. Tijerina, 1969, quote, the public has an overriding interest that justice be done in a controversy between the government and individuals, and has the right to demand and expect fair trials designed to end in just judgments. This objective may be thwarted unless an order against extrajudicial statements applies to all parties to a controversy. The concept of a fair trial applies both to the prosecution and the defense." End quote. Defendants' repeated appeals to broad First Amendment values therefore ignore that the court, pursuant to its obligation to protect the integrity of these proceedings, recognized those values, but, in balancing them against the potential prejudice resulting from certain kinds of statements, found them outweighed. Defendants' other claims also disregard the record. To begin, he asserts that the court, quote, cited no evidence supporting its findings of risks of harassment and witness intimidation, and the prosecution provided none, end quote. But several times the court and the government pointed to evidence causally linking certain kinds of statements with those risks, and defendant never disputed it. See hearing transcript at 67. The court. When Mr. Trump has singled out certain people in public statements in the past, hasn't that led to them being threatened and harassed, as demonstrated in the statements attached by the government? Mr. Lauro. Your Honor, that's totally irrelevant. The court. And the government's motion cites several of them who averred in the kinds of statements that you've asked for under oath that threats and harassment toward them had increased significantly as a result of Mr. Trump's statements about them. See order at 2. Quote, undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. End quote. See also electronic court filing number 60, failing to dispute or even discuss the testimonies cited by the government. The evidence is in the record. Defendant simply fails to acknowledge it. Likewise, defendant claims that the court, quote, gave no meaningful consideration to alternative, less restrictive measures, including a narrower order, end quote. Again, the record flatly contradicts that claim. During the motion hearing, the court questioned whether defendant's existing speech restrictions, such as his conditions of release, would adequately prevent the potential dangers to these proceedings. The court also considered whether alternative measures could prevent those harms, and in fact concluded that they could, with respect to certain kinds of statements, such as those disparaging the District of Columbia. Accordingly, the court denied the government's motion in those respects. But the court explained that alternative measures would not sufficiently mitigate the risks flowing from other kinds of statements, such as those targeting reasonably foreseeable witnesses. See order at 1 to 2. Quote, here, alternative measures such as careful voir dire, jury sequestration, and cautionary jury instructions are sufficient to remedy only some of the potential prejudices that the government's motion seeks to address, end quote. Noting that the risks created by certain statements would be irreversible. Quote, this court has found that even amidst his political campaign, defendant's statements pose sufficiently grave threats to the integrity of these proceedings that cannot be addressed by alternative means, and it has tailored its order to meet the force of those threats, end quote. The court thus tailored its order to prohibit statements only where less restrictive measures would be inadequate. Defendant's final claim is that the order is unconstitutionally vague for various reasons, none of which withstand scrutiny. First, defendant quotes Merriam-Webster Online's definition of interested to conclude that the term interested parties could include everyone affected or involved in the case. But interested party is a well-established legal term of art meaning, quote, anyone who both is directly interested in a lawsuit and has a right to control the proceedings, make a defense or appeal from an adverse judgment, end quote. Interested party, Black's Law Dictionary, 11th edition, 2019. Referencing party to Black's Law Dictionary, 11th edition, 2019. The order confirmed that scope, defining the term as, quote, including the parties and their counsel, end quote. See also hearing transcript at 83 to 84, stating that the written order would apply to the parties and their counsel. There is no meaningful basis to interpret interested parties as covering anyone else. Second, defendant focuses on the prohibition of targeting certain individuals, again quoting various dictionary definitions to assert that targeting could include not only identifying those individuals but also attacking them, subjecting them to ridicule or criticism, or otherwise attempting to affect them. But restating a dictionary to, quote, search for every facet, end quote, of relevant terms is not a proper vagueness inquiry. United States v. Braunstein, 2017, quote, rather, a statute is unconstitutionally vague if, applying the rules for interpreting legal texts, its meaning specifies no standard of conduct at all, end quote. Ibid, quoting Coates v. City of Cincinnati, 1971. And a cardinal rule of interpretation is that context matters. Quote, a word is known by the company it keeps, end quote. Ibid, quoting Jarecki v. G.D. Searle and Company, 1961. The motion hearing and corresponding order provide substantial context for and examples of the kinds of targeting statements that could result in, quote, significant and immediate risks to the integrity of these proceedings, end quote. Indeed, the court identified that, depending on their context, statements matching each of the definitions defendant proffers for the term target could pose such risks. See e.g. hearing transcript at 50 to 54, risks associated with publicly identifying court staff, Ibid at 41 to 43, risks associated with attacking prosecutors, Ibid at 59 to 60, risks associated with criticizing potential witnesses, Ibid at 13 to 14, risks associated with attempting to affect potential witnesses' testimony, even using praise rather than criticism. Defense counsel also repeatedly relied on context to distinguish permissible from impermissible statements. See e.g. Ibid at 72. The court, next hypothetical. Bill Barr is a smart guy, but he better learn to keep his mouth shut. Permissible? Or an attempt to obstruct justice or intimidate a witness? Mr. Lauro, it depends on the context. If it happened the day before Bill Barr testified at trial, that might be impermissible. Ibid at 71. A, quote, term is not rendered unconstitutionally vague because it does not mean the same thing to all people all the time everywhere. Braunstein, quoting Roth v. United States, 1957. The court's order and the motion hearings record sufficiently clarify the meaning of targeting to provide fair notice of the kinds of statements, understood in context, that it prohibits. Two of defendants' social media posts since the order's entry illustrate the comprehensible difference between the statements it permits and those it proscribes. First, on October 20, 2023, after the order was entered, but before it was administratively stayed, defendant stated, does anyone notice that the election-rigging Biden administration never goes after the riggers, but only after those that want to catch and expose the rigging dogs? Massive information and 100% evidence will be made available during the corrupt trials started by our political opponent. We will never let 2020 happen again. Look at the result. Our country is being destroyed. MAGA. This statement asserts that defendant is innocent, that his prosecution is politically motivated, and that the Biden administration is corrupt. It does not violate the order's prohibition of targeting certain individuals. In fact, the order expressly permits such assertions. By contrast, on October 24, 2023, after the order was administratively stayed, defendant stated, I don't think Mark Meadows would lie about the rigged and stolen 2020 presidential election merely for getting immunity against prosecution, persecution by deranged prosecutor Jack Smith. But when you really think about it, after being hounded like a dog for 3 years, told you'll be going to jail for the rest of your life, your money and your family will be forever gone, and we're not at all interested in exposing those that did the rigging, If you say bad things about that terrible monster, Donald J. Trump, we won't put you in prison. You can keep your family and your wealth, and perhaps, if you can make up some really horrible stuff out him, we may very well erect a statue of you in the middle of our decaying and now very violent capital, Washington, D.C. Some people would make that deal, but they are weaklings and cowards, and so bad for the future of our failing nation. I don't think that Mark Meadows is one of them, but who really knows? Make America great again. This statement would almost certainly violate the order under any reasonable definition of targeting. Footnote 5. Because of the administrative stay on the order, this statement is not before the court. Before concluding that any statement violated the order, the court would afford the parties an opportunity to provide their positions on the statement's meaning and permissibility. End footnote. Indeed, defendant appears to concede as much. Reply in support of motion to stay, quote, if the gag order had been in effect, President Trump would have been unable to make the statement, end quote. And for good reason. The statement singles out a foreseeable witness for purposes of characterizing his potentially unfavorable testimony as a lie, quote, made up, end quote, to secure immunity, and it attacks him as a weakling and coward if he provides that unfavorable testimony. An attack that could readily be interpreted as an attempt to influence or prevent the witness's participation in this case. The plain distinctions between this statement and the prior one, apparent to the court and both parties, demonstrate that far from being arbitrary or standardless, the order's prohibition on targeting statements can be straightforwardly understood and applied. Defendants' other assertions of vagueness boil down to similar objections that deciding whether a statement violates the order will necessarily be a fact-bound inquiry. He contends that it may at times be difficult to tell whether an individual is a reasonably foreseeable witness or to distinguish proclamations of innocence from attacks on prosecutors or witnesses. But even assuming that is true, it does not follow that, quote, men of common intelligence must necessarily guess at the meaning, end quote, of the order's prohibitions. Hines v. Mayor of Oradell, 1976. It is a basic mistake to derive vagueness from, quote, the mere fact that close cases can be envisioned. Close cases can be imagined under virtually any prohibition, end quote. United States v. Williams, 2008. If a party or their counsel makes a statement that may have violated the order, the court will assess its substance and context. The fact that it needs to do so with special care in close cases does not render the underlying order unconstitutionally vague. Consequently, defendant has failed to make a strong showing that he is likely to succeed on the merits of his appeal. B. Remaining factors. The remaining factors also counsel against a stay. Defendants' brief arguments on each rely entirely on the premise that the court's order violated his First Amendment rights. See motion to stay at 31. Quote, a showing of likelihood of success on a First Amendment claim necessarily establishes irreparable injury, end quote. Ibid, quote, as for the balancing of harms and the public interest, the demonstration of an ongoing violation of the First Amendment rights dictates that a stay should be entered, end quote. Having rejected that premise, the court reaches the opposite conclusions, where, quote, there is no showing of a likelihood of success on the merits, end quote, of a First Amendment claim. There is no irreparable injury or public interest favoring a stay. Archdiocese of Washington v. Washington Metro Area Transit Authority, 2018. To the contrary, quote, few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right, end quote. As discussed above, in the order and during the motion hearing, the court finds that the public interest in the orderly administration of this case requires the order's limitations on such statements. 2. Conclusion. For these reasons, defendant's motion to stay is hereby denied, and the administrative stay imposed by the court's October 20th, 2023 minute order is hereby lifted. Date: October 29th, 2023. Signed, Tanya S. Chutkan, United States District Judge. This concludes this episode of The Docket. I hope you enjoyed this episode. For updates on The Docket, please visit docketpod.com, subscribe to us on your favorite podcast platform, or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.